I call Jacinda Ardern.
Thank you, Mr Chair. It's my pleasure to take a call on what is quite a substantive bill, which to date we've been debating alongside extended supervision orders. Mr Chair, I thought it would be useful in debating part one, which sets out substantively how the public safety, public protection orders will work, to just put a little bit of context around the fact that we are debating an order which will, as the regulatory impact statement states, apply to a very small number of offenders. We are talking, as set out in part one, that the definition of the individuals who this bill will apply to probably amounts to what has been estimated, I imagine, by the Ministry of Justice to be roughly 5 to 12 individuals in a 10-year period. That's set out in some of the clauses at the beginning of the bill, which talks about serious sexual or violent offence, meaning an act committed before, on or after the commencement of this section. It's a sexual crime under Part 7 of the Crimes Act 1961, punishable by 7 or more years imprisonment. And a range of other offences as set out in that part. Now, obviously, applying what is essentially a civil order to sentences that may only reach a threshold of 7-year imprisonment may seem like a low bar to be setting, but I think the Select Committee was right in allowing the flexibility at the end of one's sentence to establish a range of other threshold tests which are quite high. So whilst the sentencing, initial sentencing bar may be considered to be low in that regard, there are a number of tests set out by this bill which are quite robust, which require a number of significant assessments which will be tailored to the time and place at which the civil order may be applied, and will have assessed whether or not any rehabilitation, for instance, has been successful or progressed with that particular offender. I'll come into that in a little bit more detail in time. But the Ministry of Justice on that basis has established roughly 5 to 12 offenders in a 10-year period. So not a large number despite the criteria being a bit broader. So that really, I think, points to the fact that the additional threshold test is quite high. I do think, though, that given we are debating a civil regime being added, and that is a significant departure from what we have currently, and given that the government has not been interested in introducing a sentencing council to assess whether or not we are appropriately and consistently sentencing in New Zealand, that it would be useful to perhaps assess, maybe via a Select Committee regime, maybe the Auditor General could, those offenders who are subjected to both extended supervision orders and public safety orders. Now, the reason I think that could be a useful exercise is, of course, we have the option of preventive detention in New Zealand. You could almost say that that's the front-end version of a public safety order. And it would be useful to assess whether or not there are common or consistent themes within offenders that these backstop measures are applied to that weren't perhaps utilised at the point of sentencing, because a preventative detention sentence is a much easier way to deal with these offenders than having to wait till they come to within 6 months of release. The trauma, obviously, that a victim goes through at the point of their sentencing and having a sentence that will come to an end, then 6 months before the end, going through the process of a decision being made that they're not safe for release and that this additional order needs to be applied. So if we had some kind of regime to look at and assess who the kinds of offenders that are having these orders apply to, and whether or not actually there are things that we're missing at the point of sentencing that our judiciary could learn from. So I'd be interested in the Minister's view on that, on whether or not we could build a process around that. Again, because it is a significant departure from our existing justice system, I think those kinds of checks and balances would be useful. I think the other important context to apply to our debate around Part 1 is the fact that we know our statistics tell us that actually only 8 or 9% of sexual assaults are even going to get to the point where they'd be considered at the point for these kinds of measures. That says something, speaks volumes about, Mr. Chair, our justice system in this area more broadly. The fact that our Crown prosecutors and our police even second guess whether they'd advise a friend or family to go through our justice system says that yes, while these backstop measures are important, we need to spend, and the government needs to focus a lot more of the energy around the process that a victim goes through to even bring an offender to this point in our justice system. Mr. Speaker, Mr. Chair, speaking specifically to Part 1, though, which does set out the assessment that's applied for a public protection order, basically the way that they function generally. I think it would be a useful exercise in that context to look at the regulatory impact statement that was carried out, and which talks about some of the alternative regimes that were considered before we got to the regime contained within Part 1. There were 5 options, as I understand, that could have been considered. The first was a strengthened version of the existing extended supervision orders, which I understand the House will be debating shortly, under which offenders would continue to be closely managed in the community. So we've actually really already got that. The extended supervision order legislation covers sexual offenders and violent offenders, which are not currently covered, so the government has essentially done both. So that one's been dealt with. The second option was the expansion of the scope of the Intellectual Disability Compulsory Care and Rehabilitation Act to enable offenders who are borderline intellectually disabled to be managed in a secure health facility until their risk is reduced. Obvious issue with this is that not every offender who will be considered an ongoing risk to the community would have an intellectual disability. And in fact, the bill in Part 1 under Clause 12 actually contains some specific provisions which treats those offenders differently than offenders who were regarded not to have an intellectual disability. In that section it sets out that where a court is satisfied that it could make a public protection order against a respondent, and that respondent may be mentally disordered or intellectually disabled, they're instead obliged, instead of making a public protection order, to direct the Chief Executive to consider the appropriateness of an application in respect of the respondent under Section 45 of the Mental Health Compulsory Assessment and Treatment Act. I would be interested to hear from the Minister, though, whether or not there's a view that actually, surely, has the Ministry of Justice done any assessment as to how many individuals may be captured by this clause? Of the 5 to 12 that we're talking about maybe being covered, have they excluded those who may fall within this reassessment regime and may be covered by the Mental Health Compulsory Assessment and Treatment Act? If so, doesn't that point to an issue with perhaps initial sentencing, that they would be considered to either have an intellectual disability or mental incapacity, which deems them fit to be dealt with with this alternative act rather than a public protection order? Does that mean that we would be perhaps the assessment regime and the initial sentencing will have been inadequate if that wasn't identified at that point? So just an interesting question there. I wouldn't mind hearing from the Minister and the Chair. So that obviously rules out that option. It wouldn't cover every target offender and cover all risk. The third option was a new civil detention order under which people, including offenders, would be detained in a secure facility in the community. Interestingly, there was a view that whilst that might cover I believe might cover the Bill of Rights Act, it was potentially too costly. Obviously it means establishing new facilities outside. Interesting that the Ministry of Justice, within its regulatory impact statement, chucked that out as perhaps the reason why they wouldn't do it in that way. Fourth, a continuing detention order in which offenders would be detained in prison. Considerable Bill of Rights issues there because, of course, we must be clear, this is not an extension of punishment. Rather, it is a civil regime in which is focused on public safety, and which is why I think we've arrived at the new form of civil detention using public protection orders, but within prison grounds. Obviously, that was seen as a neat way of covering off all of those issues. So, Mr. Chair, I think contextually it was important to look at part one within the other options that were considered, but I'd be interested in the Minister's reflection on my questions.